Good afternoon, everyone. It's my great pleasure to welcome you to today's legal webinar hosted by the Swiss Business Council in collaboration with our member, CVML Middle East. To those of you joining for the first time, a few words about the Swiss Business Council. We are a non-profit platform organization dedicated to strengthening the business, economic, and cultural ties between Switzerland and the UAE. We support Swiss and Swiss-affiliated through networking events, knowledge-sharing sessions, such as the webinar today, and ongoing engagement with local and international stakeholders. Today's session, Wills, Succession, and Cross-Border Considerations in the UAE, touches on a topic that is highly relevant to our international business community here in the UAE. Succession planning in a cross-border context is a very complex but essential area, particularly here in the UAE, where the legal systems and inheritance law differ significantly from those many of us are familiar with. Whether you're managing family wealth, running a multinational business, or simply planning your own future, it's vital to understand how your legacy is protected both locally and internationally. To guide us through these matters, we are very pleased to be joined by two distinguished legal professionals from CVML Middle East, a firm known for its deep expertise in private wealth and international legal structuring. To the two experts, a short intro. First one up is Ms. Alejandra Esmoris, is a partner at CVML and head of their private clients practice. She brings over a decade of experience advising high net worth individuals, family offices, and business owners on succession planning, estate structuring, and international tax matters. Alejandra has particular expertise in cross-border wealth preservation and works closely with clients across Europe, the Middle East, and Latin America. She has been instrumental in guiding families through multi-jurisdictional challenges, often involving complex asset portfolios and family government dynamics. The second speaker today is Ms. Perla Baaklini. She's an associate at the firm specializing in inheritance law, wills registrations, and cross-border structuring. She has advised clients on the practical application of both the IFC and Abu Dhabi wills regime, probate matters, and succession planning for UAE-based and international assets. Her work focuses on ensuring that expatriates living in the region have a clear, enforceable plans in place that align with both local and foreign laws. Together, these two experts will provide insights today into how inheritance succession laws apply here in the UAE, the options available for expatriates, including the IFC and Abu Dhabi wills, key consideration when dealing with cross-border estate planning, and last but not least, and I think almost the most important topic, practical steps to avoid common legal and administrative pitfalls. I encourage all of you to take full advantage of their expertise. Please feel free to submit your questions via the chat function during the session, and the expert will try in the end to address as many of those questions as possible. And with that, Alejandra and Perla, thank you for being with us today, and I'm happy to hand over to you. The stage is yours, Alejandra. Thank you.
Thank you very much, Michael, for this introduction and your kind words. And thank you to the Swiss Business Council for hosting this webinar today on will, succession, and cross-border considerations in the UAE. So this is indeed, I would say, some sort of hot topic, as we have seen many changes occurring over the last couple of years, with lately the implementation of a new federal law for the personal status that has replaced the previous law of 2005. So thank you very much for joining us today. And just to give you a very brief intro, so the aim of this session is really with the aim to bring some awareness about the UAE inheritance legal framework. And We will try also during this process to demystify some preconceived ideas that you might have, notably regarding the devolution of your assets to your relatives, and also regarding guardianship questions. We will also share some, I would say, practical insights and real-life cases that we have been handling over the past years, including regarding probate proceedings, in particular with DFC courts and Abu Dhabi courts. And while presenting the legal framework, obviously we will address also some key aspects when expats are interested in preparing and registering wills in the UAE, and what you need to take into consideration when it comes to local probate proceedings. So the agenda of today will be the following. So we'll start with a general introduction on the UAE inheritance laws, for you to understand what are the different regulations that might apply, and understand a bit more how those regulations might apply when you don't have a will in place, and what are the will options. We'll then continue with the key aspects to take into consideration for the preparation of wills. We will review a bit more in depth the DFC legal framework, and then the Abu Dhabi legal framework, and compare a bit both options for you to understand the pros and cons of each option when it comes to the preparation and registration of wills. Then we will continue with a small case study with cross-border aspects to, I would say, address some of the typical questions that we will assess when preparing a will for a client. And then we'll finish with some takeaways, and we will have a Q&A session at the end, where we will try to take as much as questions as possible, depending on the time left. So now, without further ado, we will start with a brief introduction about the UAE personal status laws that covers family matters, including inheritance and wills. So the UAE personal status framework has undergone significant reforms over the past 4 years, reflecting the UAE broader efforts to modernize its legal system while respecting cultural values. The journey began, I would say, not 4 years ago, but 2 decades ago, with the enactment of the initial federal law number 28 of 2005, on the personal status. This was the first step, I would say, to establish an unified personal status code grounded in Islamic principles, governing matters such as marriage, divorce, custody, and inheritance. Over the years, it appeared that this law was not necessarily adapted to the growing expat community in the region, and the law has been subject to many amendments over the years. But really, the breakthrough, I would say, is in 2021, when Abu Dhabi introduced a landmark legal reform with the enactment of the Abu Dhabi Law number 14 of 2021 regarding civil marriage and its effects for expats. Because this law was not only related to marriage, divorce, and other family-related matters, but also related to inheritance and wills. And it was really for the first time that a local regulation was embracing secular principles and some international best practices for expats in regards to family matters, to allow, for example, to have civil marriage, joint custody, with the recognition of the gender equality between men and women, with simplified divorce proceedings without the necessity to demonstrate, for example, the fault of the other spouse when you don't have an agreement to file for divorce. And it was also a novelty regarding inheritance, because new rules not based on Sharia for the devolution of assets were implemented at the local level. In 2022, we have seen a new landmark development at the federal level with the enactment of the Federal Decree Law number 41 of 2022 on the personal status for non-Muslim, which has introduced similar secular principle for non-Muslim expats. But I have to say that the legal framework in Abu Dhabi and the legal framework at the federal level are not exactly the same, in the sense that in Abu Dhabi, this regulation applies to expats, in particular for inheritance aspects. It might apply to expats independently of the religion, meaning that even if you're Muslim, as long as you're an expat, you might have the possibility to register a will and be subject to that regulation for the devolution of your estate. While the federal law of 2022 applies only to non-Muslim expats. And finally, in 2024, the UAE has enacted a new federal law number 29 of 2024 that has repealed and replaced the historical personal status code of 2025 that is much more modern and flexible, while preserving the, I would say, Sharia-based framework for Muslim, notably in relation to the devolution of the succession in accordance with Sharia principles. So the legal framework in the UAE is not necessarily completely straightforward, because as you can see, we have different set of rules that might apply depending on different aspects. One of them is the residency. Another of them is related to the religion, and at the end, there is also the question of the location of the assets in the UAE. So there is some sort of an interplay through the different regulations that might occur, and as there is from time to time some sort of uncertainty about what would be the outcome if you don't have a will, I would say that the best way to address this uncertainty is actually to have a will to clarify what is the governing law to your succession and what is the competent jurisdiction to handle actually the probate proceeding if something happens to you. So one of the points that is also important to understand is, for example, under the Abu Dhabi law legal framework, if you don't have a will registered and you're resident in Abu Dhabi, eventually this law might apply to you. And if you don't have a will, the split is not based anymore under the Sharia principles, but eventually your surviving wife or husband will inherit 50% of your estate, while the children will inherit the remaining 50% in equal share, independently of the gender. The same applies normally at the federal level for non-Muslim expats. However, if there are other questions, typically regarding to the guardianship of minor children that are not addressed in the Abu Dhabi law of 2021 or the federal law of 2022, notably because the executive regulations have not been issued yet. And as those executive regulations have not been issued, there is a risk that Sharia principles might apply in this regard. And here is where, for instance, if you have a father who passes away without a will, and the court that would be competent for the probate proceeding decides to apply the Sharia principle, then it means that eventually it's the first male relative of the husband who passed away who would be appointed as legal guardian of the minor children rather than his wife. And this might be quite unsatisfactory for Western expats and source of concern for many women in the region. So that's the reason why, I mean, there are some aspects that, although we have seen a very interesting evolution towards something more modern, more flexible, and taking into account the, I would say, more Western mentality towards some specific questions regarding the devolution of assets, regarding guardianship, there are still, I would say, some uncertainty. And although I have to say that we had recently quite a positive experience, for instance, with Abu Dhabi courts, where in a case where a woman has lost her husband while having a 2-year-old daughter, although the husband didn't have a will in place, we were successful to secure the appointment of the surviving wife as administrator of the estate, and also to confirm her appointment as legal guardian of her daughter without, I would say, a very lengthy process. It was quite clear that for the court, as we have now this gender equality principle under the law, and that normally, typically in case of divorce, we should have some sort of joint custody, unless it's removed from one of the parents, the same kind of secular principle should also apply in regards to the inheritance case, and therefore they have confirmed her appointment as legal guardian, which was really source of concern for this mother because of her own Muslim background. So I have to say that in this regard, at least our experience was that the Abu Dhabi courts were quite progressist and a bit eventually more in favor of the application of secular regulations, and it remains to be seen if Dubai courts or courts in other Emirates will have the same kind of approach regarding this specific question. But in any case, a simple way to avoid such traumatic experience for any relative is to have actually a will registered in the UAE, as through a will you can very easily address all those points. Currently, the main options that we usually recommend to our clients are DFC wills and Abu Dhabi civil wills. Under both legal frameworks, the testator has complete testamentary freedom in the sense that testator may decide to distribute their assets as they think fit. There is no forced heirship rights that apply in such cases in regards to the UAE legal framework. However, this doesn't mean that if, for example, you have assets in another jurisdiction, you have not forced heirship rights resulting from foreign regulations where the assets are located that could have an impact. Okay, so here we are discussing about from a UAE perspective, but just keep in mind that if you intend to execute your UAE will registered either in DFC or in Abu Dhabi in a foreign jurisdiction, eventually that foreign jurisdiction might have some specific forced heirship rights in their local regulations, and therefore trying to execute the DFC will or the Abu Dhabi will in that jurisdiction that does not comply with the forced heirship rights might be contrary to the public order in that jurisdiction. So whenever the testator is planning to draft a will to cover assets not only in the UAE but to cover assets in other jurisdictions, we need to keep in mind those specific considerations. But we will get back to this specific point a bit later. So as I mentioned earlier, so the main options For non-Muslim expats, DFC will, Abu Dhabi will. The key aspects that we usually we will address in a will are related to who will be appointed as beneficiary, who will be appointed as executor, administrator, trustee, what is the extent of the coverage of the will, and questions related to guardianship. Obviously, you can include other aspects than those ones. Typically, we can also include burial arrangements, if there is any specific conditions as well that need to be included, or an usufruct. So those are all points that we can include in the wills. But the main aspects that we usually discuss with clients when we have the initial assessment is really about if what are your actually wishes in terms of who should be your executor to make sure that the estate will be managed and distributed according to your wishes. Who do you trust? The beneficiaries. So who are the beneficiaries? And if you want to do any sort of gift or bequest, please let us know in order to include those specific instructions in the will. And one of really the point that is really key in this aspect is also to understand if only UAE assets will be covered, or if we should cover assets in other jurisdictions, either worldwide or eventually limited to some other foreign jurisdictions, depending on the situation, and the guardianship. And the guardianship is really something that is extremely important to keep in mind, because you can have peace of mind, I would say, once you have put in writing that eventually your surviving wife or surviving husband will be the legal guardian of the children if something happens to you. And then you have the possibility as well to appoint interim and permanent guardians in case something happens to both parents at the same time. Now, let's continue with, I would say, more the legal framework. So we have two main legal frameworks for wills, which is the DFC legal framework and the Abu Dhabi one. So for the DFC legal framework, the DFC Will Service Center was created back in 2014. And the governing law for wills in DFC is the DFC Wills and Probate Registry Rules of 2019. Currently, there are over 11,000 DFC wills that have been registered in 2024. And the requirements are very basic in the sense that you should not be a Muslim, you should be over 21 years old, you should have mental capacity, and you should not be acting under duress. But you don't need to be resident in the UAE to register a DFC will, in the sense that the moment you have assets in the UAE, this might be sufficient to register a DFC will if you wish so. And this is quite, this is really very useful to facilitate typically for entrepreneurs and clients who have, for example, some investments in real estate in the UAE, to facilitate the transfer of those assets if you have a will register in the AFC, because the process might be much more complex if you have only a foreign will, or that you need to wait for having a heirship certificate from a foreign jurisdiction for enforcement here in the UAE. Advantages. So you have certainty and control with a will. You can address the guardianship. You have a clear legal framework. I would say the DFC courts and the DFC will services, they have quite a long experience now handling registration of wills and probate proceedings. And the advantage of the DFC legal framework is that they have also all the executive regulation that have been already issued. And from a practical perspective, They are very supportive whenever you have any question. And when you, for example, you go through the probate proceeding, it's really an advantage dealing with DFC courts, because they can really guide the executors in their mission to make sure that they're putting in place an inventory of the assets, etc. And at the same time, if there any sort of question, we can go to the regulation to see how this question should be addressed. So I would say that there are plenty of advantages. The downside eventually of the DFC legal framework is the fact that it's quite expensive. So for the registration of a full DFC will, a single one, you have to count a disbursement of 10,020 dirhams, while if it's for mirror wills for a married couple, the disbursement is 15,020 dirhams, which is quite expensive compared to Abu Dhabi. We'll get back to this point later on. And now I will leave the floor to my colleague Perla to give you a bit more information about enforcement of DAC wills and how the process is handled.
Thank you, Alejandra. Yes, thank you, Alejandra. Now that we've explored the legal framework of the DFC wills regime, we can walk through the practical side of things. Specifically, what happens when a DFC will needs to be enforced and how we obtain a probate order. So the process, as mentioned by Alejandra, is governed by the DFC wills and probate rules. It's a process we've handled many times when assisting clients, and we can tell you it's streamlined and very efficient. Everything typically starts with an online application through the DFC court portal. The application itself includes, of course, a copy of the registered will, the probate application form that we can find on the portal, along with other documents required by DFC, like the witness statement, and passport copies of the testators and the beneficiaries, and of course, a list of the deceased assets in both English and Arabic. And that's why when we register wills, we always advise clients to keep a list of assets with their spouse or with the executor name in the will, and to keep it updated at least once a year. To file the probate application at this stage, there's no filing fee and there's no physical submission required. So the executor named in the will doesn't have to be physically in the UAE to file the probate application. Once the application is complete, the DIFC courts will schedule a virtual meeting with the executor. The executor will join the meeting and will sign the documents that he submitted online electronically, because when the executor submits the documents, it will be unsigned and undated. He will confirm the content and his wish to proceed with the probate during the meeting with the officer. They, of course, will need to present their original ID and the original death certificate during the meeting. If everything is in order, the probate order is usually issued within 2 weeks of that meeting. In our experience, the timeline is very reliable, especially when the documents are well prepared. Now, once the order is issued, we move on to the enforcement. If the assets are inside the IFC, the order is directly enforceable. However, if the assets are outside, like in mainland Dubai, we have to file a further application. It is what we call an enforcement letter. The executor will need to submit an enforcement application to the DIFC courts, who will then send a request to the Dubai courts, who in turn issue enforcement letters to the relevant authorities, whether it's a bank, whether it's a land department, or the RTA. So in summary, the DIFC probate and enforcement process is very clear, very structured, and can be done fully online. It's a system that works and can be relied on, and we've seen firsthand how it brings peace of mind to families during the most difficult times of their lives. In many of these cases, we've been appointed by the executors themselves through a power of attorney, allowing us to assist them with filing the probate procedure on their behalf, which makes the experience much smoother, especially for executors who are based abroad or unfamiliar with the system. So it's very reliable. It can be done online, and it's not that lengthy. So I think now it's safe that we can move on to the legal framework for the Abu Dhabi Civil Family Court. Back to you, Alejandra.
Thank you very much, Perla, for sharing those, I would say, more practical insights regarding enforcement of DFC wills, because we often discuss just about the will registration itself, but the subsequent enforcement is indeed quite smooth with the DFC courts, although there are, the enforcement letters to request still entry to the local local courts to finalize, I would say, the distribution of the assets. But indeed, it's very efficient, and now we have, I would say, this Abu Dhabi Civil Family Court that is, to a certain extent, a competitor to DFC courts when it comes to inheritance process and registration of wills. So the Abu Dhabi Law number 40 of 2021 was enacted in November 2021 with the creation of the Abu Dhabi Civil Family Court in 2022. I have to say that at the beginning it was quite challenging dealing with them because everything was new, and no one was necessarily aware about how to deal with civil marriage, with inheritance procedures, registration of prenup and post-nuptial agreements. However, I have to say that now, in 2025, things seems to be handled in a more efficient, very much efficient way. And what we have seen is that really the possibilities to register wills with them is efficient, and the probate proceedings is in a similar way very straightforward. So currently, based on this, on the Abu Dhabi legal framework, expats, Muslim and non-Muslim expats, have the possibility to register civil wills to decide how to distribute their assets, and it's the process is very similar to DFC in the sense that the registration process is done also online, and there is no, I would say, very many formalities to be done, except that compared to DFC, for Abu Dhabi, you need to prepare your will in English and Arabic, while in DFC, the will is only prepared in English. And then the registration is a bit different as well, in the sense that you don't need to have witnesses for the registration of your Abu Dhabi will, while for DFC you need to have two witnesses. So here we have prepared some sort of comparative table just to compare DFC will and Abu Dhabi will. So basically, the governing law is different, but you will reach the same outcome because you have testamentary freedom under both regulations. The competent jurisdiction for a DFC will be exclusively the DFC courts. For an Abu Dhabi will, it will be the Abu Dhabi Civil Family Courts. The language for DFC wills is English. For the Abu Dhabi Civil will, it's English and Arabic. So everything is done in both languages. And for registration, you need two witnesses for the registration in DFC, and for Abu Dhabi, it's only the testator. In DFC, I mentioned previously, but just to clarify, we have 6 different types of wills. The full DFC will is usually the most common type because you can encompass all your assets and address the question of the guardianship in that will. But as business owner, for example, you could decide that you don't want to have a full will, you just want a will to address the question of the transfer of your shares. And they have these limited wills in DFC. In Abu Dhabi, you have only one type of will. So it's you can cover everything under the will registered there. In both cases, the testator must be major, sound of mind, For DFC non-Muslim, for Abu Dhabi non-UAE citizen. In terms of coverage, you can cover your UAE assets and your worldwide assets in both options. However, for execution purposes in other jurisdiction, we might face some challenges. So it's always very important to determine whether or not it makes sense to encompass worldwide assets in a will register in the UAE, or if it would be better to register separate wills in the corresponding jurisdictions and to facilitate, I would say, the probate proceeding and the distribution of assets. Regarding forced heirship rights, as I mentioned, there is testamentary freedom in both. Guardianship provisions, you can include such provisions in both wills, but the difference, I would say, is regarding declaration of guardianship. For DFC wills, guardians who are not the surviving spouse will need to sign a specific declaration before the registration of the will, while in Abu Dhabi, this is not requested. And I would say, obviously, one of the biggest, I would say, differences regarding at least the registration aspect is the cost. In Abu Dhabi, registering an Abu Dhabi will is only 950 dirhams compared to 10,020 dirhams in DFC for a full DFC will. There are also, I would say, interesting aspects to take into consideration when it comes to the enforcement of Abu Dhabi civil wills with the Abu Dhabi Civil Family Court, and Perla will now give us a bit more information about the process.
Thank you, Alejandra. And indeed, while the process of registering a will with the Abu Dhabi Civil Family Court is quite similar to registering a will with the JFC courts, also the process of enforcement of a civil will shares some similarities with obtaining a probate order in JFC. However, the enforcement of a will through the Abu Dhabi Civil Family Court follows, I can say, its own special steps. The process here begins with an online claim rather than a probate application. The claim is also submitted online through the Abu Dhabi Civil Family Court portal with all the required supporting documents. Everything and every supporting document should be submitted both in English and in Arabic and signed by the beneficiaries or the executor starting the probate procedure. However, one of the most important documents is the inheritance claim form. The inheritance claim form can be also downloaded through the portal, must be filled out both in English and in Arabic, and it must be signed by the executor and submitted along with the supporting documents. And in that form, we need to explicitly select and request the court to distribute the estate in accordance with the registered will of the testator. All the supporting documents, like I said, should be submitted both in English and Arabic, like the copy of the duly registered will, a list and description of the assets, along with supporting documents like title deeds, bank statements, a list of any minor, if applicable, the death certificates, the marriage certificates, if applicable, and the birth certificates of the heirs. Once the claim is submitted, the court will review it, and this usually takes around 5 to 10 working days, I can say. And if there are no further comments or requests for clarification, a court preparation session is scheduled. This court preparation session is not yet a hearing. However, it's an administrative meeting where we can meet with the case manager or the case officer and finalize and confirm our wishes to proceed with the probate procedure. Once that step is completed, the case moves forward now to the court hearing, which is typically also very efficient and usually lasts around 20 minutes. However, it's conducted in Arabic. Now, if the client doesn't speak Arabic, we can, of course, request a translator to be present during the meeting. 2 weeks after that hearing, the judge will issue then its decision. So although it's handled a bit different from the JFC probate system, the enforcement process through the Abu Dhabi Civil Family Court is just as structured, just as efficient and accessible when properly managed and when we properly prepare all the documents and the requested information. And I can say we highly recommend to register either a will with the IFC or Abu Dhabi, because the probate procedure with both is efficient when we properly manage it, and it's less complicated than having to start the probate procedure when we don't have a will in place. So I think now we can move on to a case study that we have prepared. We have a case study and we have a family structure. We have a married couple with the female being a Swiss non-Muslim and a UK Muslim husband who is 55 years old. Together they have 2 kids, a boy, Hans, he's 18 years old, and a girl, Claire, who is 15 years old. They are living in Dubai, and they have joint assets, and they have personal assets, each one of their own. So I have the wife who have a UK real estate, a Swiss real estate, UAE company shares, etc. And Adam, who has also real estate in UK, real estate in the UAE, and company shares in the UAE, and bank accounts in Jersey. And they have also joint assets together in the UAE. They have shares in a BVI holds company, and they have real estate in the UK. So the questions are for Alejandra. What would you recommend in terms of wills for each spouse and why? And also, what factors should we consider when advising the clients on the wills, and what other solutions could we consider?
Thank you, Perla. So now going back to the case study. So here you see you have a couple with mixed religion. So what you will suggest for one might not apply for the other one, at least in regards to the UAE. In this specific case study, so this couple is living in the UAE. She's non-Muslim Swiss. He's Muslim from the UK, and therefore, for her, we have potentially 2 options: the DFC will or the Abu Dhabi will. While for him, the only option would be to have the Abu Dhabi will. Then the question would be whether or not it makes sense for both of them to have just an Abu Dhabi will, to make sure that we have actually the same jurisdiction that would be competent if something happens to both of them at the same time. Or if we are comfortable having, for example, for her, the DFC will, for him, the Abu Dhabi will, but make sure that we don't have contradictions, notably regarding the guardianship provisions for the minor children. And so here is where we have both options. And regarding the coverage, so obviously, in both cases, the wills for her and the will for him will cover the UAE assets. However, for Lieselot, who is a Swiss citizen, and she has also assets in Switzerland, we could potentially consider having a separate Swiss will to address her inheritance related to the Swiss assets. I will not recommend her to necessarily address all her succession through a Swiss will, because she has potentially UAE real estate assets, and she has also shares in a company in the UAE. And therefore, if I have only a Swiss will registered for her, in terms of execution of that foreign will in the UAE, this might be extremely complex, because first of all, you will need to do a certain number of attestation of different documentation and eventually obtain some sort of additional court orders from Switzerland to confirm to have, for example, the heirship certificate issued by the Swiss the Swiss courts before coming to the UAE in order to handle the UAE estate. Therefore, I would say that most likely as she's resident in the UAE, I would address the question of the the estate in the UAE through eventually, depending on the value of the UK real estate, either we could cover this under the DFC real estate, and the DFC regulation is based on English law. Eventually, I would have a tendency for her to do eventually a DFC will to cover the UAE assets and the UK assets, and eventually the Jersey bank account. Then for him, the reasoning is, I would say, quite similar. But here is where, as he's not Swiss national, and he has only Swiss investment portfolio, I would say that we could cover eventually all those aspects through the Abu Dhabi will. And again, depending on the size of the real estate portfolio in the UK, eventually we should consider having a separate will register in the UK. In any case, one thing that is important to keep in mind is that regarding the children, there are still, the majority in the UAE is 21 years old. So we will have, in particular for Claire, we need to address the question of the guardianship in the will register in the UAE for both of them. And hence, as he's only 18 years old, he cannot be appointed as an interim or permanent guardian for his sister if something happens to both of his parents. Another point is that he couldn't be appointed as executor neither, because he's not yet 21 years old. However, except for that, let's say, for example, they register a will now and they would like to modify their wills when Hans reached 21 years old. Indeed, they can do modifications of their wills whenever they want, until they have the mental capacity to do so before their passing. Regarding other solutions, we should also consider that wills address a specific event which is related to the death, but it doesn't address the questions related to incapacity, to mental incapacity. And for mental incapacity, unfortunately, at this point on time, we don't have lasting powers of attorney in the UAE that might be registered, but eventually in Switzerland or in the UK, you have the possibility to register lasting powers of attorney. So depending on the situation and where are located the assets, eventually it can make sense also to have this tool in place to make sure that if something happens to you and you don't have the mental capacity to do further to manage your assets, eventually there is some sort of solution that is implemented to facilitate the management during this period. Other things that we can also consider typically for the BVI holdco shares is to have joint survivorship rights, meaning that the shares are owned jointly by the couple, and if one of them passes away, the shares automatically remains with the surviving spouse. So now I think we reach the end of the case study. And so what we, I would say in terms of takeaways, what is really important is just to keep in mind that succession planning shall be adapted according to the personal circumstances of the testator. What might be a good solution for one of you might not be the best one for others. And there is not just one solution. And what is important is just to make sure that you are aware of what are the consequences, and to not only because registration of a will in DFC or in Abu Dhabi is quite simple. But what we need to make sure is that when we reach the enforcement level, what has been implemented is efficient to facilitate the life of your loved ones. And having multiple wills in this regard might facilitate the probate proceedings, especially when you have important assets, in particular real estate assets, in different jurisdictions. And it might be more adapted than just having one will covering not only the UAE assets, but worldwide assets. But if you have multiple wills in place, one of the things that you need also to take into consideration is that there is no conflict among those wills. So that is the reason why it's always very important whenever you're discussing with a legal counsel, an advisor about your succession planning, is to inform that legal counsel that you have already a will in place somewhere, because that way we can make sure that we implement the right provisions in the wills to avoid, first of all, to revoke a previous will that would have been registered in another jurisdiction, and also ensure that there is no conflict between the different documents. And another point is, while enforceability of UAE wills, either in DAC or Abu Dhabi, might be quite straightforward in the UAE, this might not be the case in other jurisdictions, depending on the legal framework in that specific jurisdiction. So having eventually separate legal advice from a lawyer or legal counsel in that foreign jurisdiction might be advisable, just to make sure that what is implemented in the UAE can be properly enforced in due course in that foreign jurisdiction if necessary. You have for some countries, you have bilateral and multilateral treaties with the UAE that facilitates recognition of foreign legal documents, but it's not necessarily always the case. So just keep this in mind, because obviously the cost aspect is important, but putting in place something that will not work at the end, I mean, it's a pity, because it might be addressed quite in a simple way if the right advice has been taken. So that's the reason why we always recommend to seek for further legal advice whenever it's necessary. On our side, we are working with law firms in different jurisdictions for cross-border situations in Germany, in France, in Spain, and we tend to try to come up with some sort of global succession planning, and eventually the UAE might be, or the will in the UAE might be the umbrella will to cover most of the aspects, but depending on the situation, eventually a will in the UK or in another jurisdiction such as Switzerland might be very, very useful, and then the will in the UAE might be limited just to the UAE assets. So again, there is no just one solution. There are plenty of solutions, but it's important whenever possible not to leave a situation that would be uncertain without a will. So of course we are here to help you whenever it's necessary. And with that, we reach the end of this presentation, and I think we have still a couple of minutes to take some questions.
I think we have some questions in the chat box, so I can read it.
Yeah.
I think, Desiree, how do you handle will registration if you are not a UAE resident but have UAE assets to consider?
So typically, if you are non-Muslim, we can proceed with the DFC will registration, and because the having a residency visa in the UAE is not requested. We will in the will mention that you're a resident, your address of domicile that is outside of the UAE, but in that case, I would say that your DAC will should not cover your assets outside of the UAE. It would be limited to your assets inside the UAE. But the fact that you don't have a residency visa is not an issue to register a DFC will.
Okay. We have Natasha. Is there a limitation for guardianship based on where you live?
So limitation regarding guardianship provision, how it works is usually when the children are living in the UAE with the testator, that we will include guardianship provisions in the wills. let's say, for example, you live outside of the UAE most of the time, or eventually you are resident and spend most of the time in the UAE, but actually your children are living outside of the UAE and they are minor. So in that case, normally we will not address the question of the guardianship from a UAE perspective, because this is not the usual place of residence of the children, and this question will be eventually should be assessed eventually from the legal framework from the country where the children are usually living.
Okay, we have a question from Nisha. Can we also explore the option of registering a will in the ADGM courts? Which do you think is the better option between ADGM courts and Abu Dhabi Civil Court wills?
Okay, so this is because here the presentation was focusing on the main two options that we are usually recommending to our clients, which is the DFC will or the Abu Dhabi Civil will. But they are not the only options. And indeed, there are, I would say, two additional options. For example, registering local will with the Dubai courts, or registering a will with ADGM. However, for ADGM, to be honest, not very clear, because first of all, you need to have some sort of nexus with ADGM, and then ADGM does not have any specific regulation to handle later on really the probate proceeding, and then it will eventually go back to the ADGD. So I would say that from my perspective, I will not recommend doing an ADGM will, and I will go for a civil will with directly with ADGD, which is the civil will with the Abu Dhabi Civil Family Court.
Yes. We have also a question from Rajiv, that the documents to be submitted along the inheritance claims require attestation by a notary public, or legalization or originals only will work?
So the attestation aspect is quite important, and we're talking about attestation and legalization up to at least the MOFA here. So meaning that, for example, if you have a death certificate that has been issued in a foreign jurisdiction, this death certificate will need to be authenticated by the local authorities in that jurisdiction before being attested by the UAE embassy in that jurisdiction. Then we will need to receive the original here in the UAE to arrange the MOFA attestation, and then proceed with the translation eventually in Arabic, depending which court is competent. In certain instances, we had also to organize further attestation with the Ministry of Justice. So just keep in mind that the attestation process is extremely lengthy, it's quite annoying, but for the moment, this is what we have to deal with. And we did it for example, Indian families, French families, UK families. And it's always a question of how fast the families might manage to get the documentation duly attested in their home countries, where eventually the testator passed away.
Okay. We have also one question. What is the advantage of a DIFC will versus a will attested directly at a local notary?
So let's say you have your will attested with a local notary in Dubai versus a DFC will with the DFC courts. Then once you will open the inheritance case with the Dubai courts, you will have eventually to go in person with two witnesses, two male from the same religion as the deceased person, to open the inheritance case with the will. And the whole process will be in Arabic, and it might be quite challenging to understand what needs to be provided and to get the right information from to facilitate the process. The advantage of having a DFC will is that first of all, the process will be handled in English. that the whole process, or at least the initial process until the issuance of the grant of probate will be done online. And this facilitates for family members, for example, who are not living in the UAE, to handle the process by themselves, or to participate in the process with the assistance of a legal representative who can file all the necessary documentation. For the process with the Dubai courts is a bit different, and the Arabic aspect might be from time to time a challenge for Western expats.
Exactly. Do we have time to take on more questions?
Laetitia? Maybe we can still take at least one question.
Okay. Can citizens from GCC countries also register a will with the Abu Dhabi courts? And can Muslims avoid Sharia law completely? Or does even the will with ADGM court have to follow Sharia principles in some areas?
So it's a very good question, and here is where we don't have yet full clarity. According to the regulation, any expat who are not UAE citizen potentially may register a civil will in with the ADGD. However, here is where when you have a GCC person where normally Sharia law applies according to their nationality, from our perspective, this might be an issue. And with this kind of will, in any case, you will not be able to address any succession aspect related to your assets in the GCC outside of the UAE. So currently, I never had the case for a Saudi, typically a Saudi person who was asking to do this kind of will, but I would say that this is risky, and this might be subject to further dispute later on because of the fact that the nationality of the person is from a country where Sharia law applies. For a Western client who is an expat Muslim, but for example from France, from the UK, we're expecting to have not to face such kind of challenges because the law, the national law of that expat does not apply Sharia principles. But for the GCC, it's we will see once we will have I would say additional case law that might be issued in this regard.
Okay. I think we can take one more question from Jocelyn. She's saying we have a will in Abu Dhabi which dates from before ADGM existed. What should we do?
So in that case, I would say that it's worthy to reassess the situation and eventually re-register the will under the new regulation.
Indeed. So I think this is everything. Oh, we have one new question. No, this is everything, I think.
Perfect. So thank you very much for attending this this webinar, and please feel free to contact us if you have further questions about your own succession planning, and we are more than happy to jump on a short initial call just to see what is your situation and what we could explore together regarding registration of wills. And regarding the presentation, I believe it might be shared by the Swiss Business Council after the session. So please, if it's not the case, you can just drop me an email, and I'm more than happy to share it with you. So thank you again for your attendance today, and I wish you a very good day.
Thank you very much.
Everyone.
Have a good day. Bye-bye.
Thank you.
Bye-bye.
Bye-bye.